And they said that they'd been denied the ability to marry, which was a basic civil right, and that this excluded them from full participation in society, full membership of society, and that they didn't have an option to choose whether to marry or not, as heterosexual couples do. So this was a good opportunity for the UN to really interpret what Article 23 of the ICCPR meant. And it was argued, as I sort of said earlier, that just because Article 23 refers to men and women doesn't mean it refers to men marrying women. It refers to men as a group, and women as a group may marry who they choose. The Human Rights Committee rejected that argument, and what they said was, given the existence of a specific provision in the Covenant on the right to marry, any claim that this right has been violated must be considered in the light of this provision. Article 23, paragraph 2 of the Covenant is the only substantive provision in the Covenant which defines a right by using the term men and women, rather than every human being, everyone, and all persons. Use of the term men and women, rather than general terms used elsewhere in Part 3 of the Covenant, has been consistently and uniformly understood as indicating that the treaty obligation of state parties stemming from Article 23 of the Covenant is to recognise marriage only the union between a man and a woman wishing to marry each other. Now, a couple of things that I'd point out about this case is the timing of it. When Jocelyn was being considered by the Human Rights Committee, there was only one country in the world that had legalised same-sex marriage. Does anyone know which country that was? First country legalised same-sex marriage? Sorry? Sweden, not Sweden? No. What, sorry? No. Scotland still hasn't legalised it. No, it was actually the Netherlands. Netherlands was the first country in the world that legalised same-sex marriage, and they did that in 2001, so about a decade ago. So when the Human Rights Committee is considering Jocelyn, the status around the world was still that marriage was between a man and a woman, and you see that in the language. They say has consistently and uniformly been understood. So they're taking that sort of historical, traditional approach of this is the way it's always been done. But it has been argued that the reference to men and women in Article 23 isn't as clear-cut as the committee made out. Australia has made it more clear-cut. When other countries around the world started to legalise same-sex marriage, some same-sex couples went overseas, in particular to Canada, where they were legally married, and then their intention was to come back to Australia and petition to have their marriage recognised, because Australia, under its international law obligations, is required to recognise marriages legally performed in other countries. So John Howard, as then Prime Minister, moved very quickly to amend the Marriage Act, which did not refer to men and women at all. He took the step of initiating legislation that says that marriage is the union between a union of a man and a woman to the exclusion of all others. So the definition in Australia in the Marriage Act of marriage is actually narrower than in the ICCPR, and that's the definition that we still have to this day. So many would argue not a good outcome in terms of bringing a complaint to the Human Rights Committee about Article 23. However, Jocelyn didn't limit the arguments to Article 23. They also raised arguments under Article 16, 17 and 26, and I just want to briefly touch on each of those. So Article 16, we'll start with Article 26, which is the anti-discrimination provision. And I would argue that it is an umbrella provision, if you like, of the ICCPR, in that all persons are equal before the law and are entitled without discrimination to equal protection. And persons cannot be discriminated on the grounds of race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. So very broad grounds on which states are not allowed to discriminate. And had the Human Rights Committee considered New Zealand's Marriage Act in terms of Article 26, which they declined to do, because they said we've already decided this under Article 23, we don't have to look at Article 26. I think that was a flawed approach. Had they looked at under Article 26, they would have really struggled to say that the Marriage Act does not violate Article 26. And that is because, as I said, it's an autonomous right. It's not linked to any other provisions of the ICCPR. It applies broadly to all state action, and furthermore, the Human Rights Committee in previous decisions has already found that those various categories of discrimination in Article 26, sex, religion, other status, etc., in Toonen it was held that sex includes sexual orientation. And similarly, in the case of Young, the Human Rights Committee again said that Article 26 protects people discriminated against on the grounds of their sexual orientation. You might recall in that case, Young's partner died. They'd been partners for decades and decades, and he said he was entitled to the widow's pension, just as all other widowers of married or de facto heterosexual couples were entitled. And the Human Rights Committee found that the Act, in excluding a member of the same sex from the benefits available to a member of an opposite sex in the same circumstances, violated Article 26 of the ICCPR. And interestingly, this decision was the trigger for very wide-ranging law reform in Australia to remove discrimination against same-sex individuals and couples from, I think it was over 100 pieces of legislation. The only areas where same-sex persons remain discriminated against in terms of legislation is marriage and in various state laws relating to adoption and access to fertility treatments and things like that. But in terms of now pensions, tax, childcare rebates, all those sort of things, it's now doesn't matter whether you're heterosexual or homosexual. The last article in the ICCPR that I want to look at in terms of a provision that impacts particularly on this issue of same-sex marriage is Article 17, and that says, "No one shall be subjected to arbitrary or unlawful interference with his privacy, family or correspondence, nor to unlawful attacks on his honour and reputation." Now, arguably, Article 17 has the effect of saying that an individual has the right to choose their own form of sexual expression and to establish private relations, and that as the committee, the Human Rights Committee in Toonen held, the concept of privacy encompasses consensual sexual activity between adults, and that is something that goes on in the sphere of marriage. So I'd argue that by limiting who a person can marry to someone of the opposite sex, even if you happen to love someone of the same sex, is an infringement of Article 17. Again, it was an argument that was raised by Jocelyn but not dealt with by the Human Rights Committee because they decided that they only needed to reach a decision based on Article 23. So now I want to move on to some of the other international human rights provisions that I say impact on this issue of same-sex marriage. And let me turn to ISESCA, the International Covenant on Economic, Social, Cultural Rights, and I'll give you a moment to read Article 10 up there. Because I think when it comes to campaigning for law reform relating to same-sex marriage, one of the strongest arguments relates to family and children. Because same-sex couples are increasingly starting families, having children, and as Article 10 of ISESCA says, the widest possible protection and assistance should be accorded to the family. Not should be accorded to heterosexual families, should be accorded to the families. And I actually found a few minutes this morning to have a look at the Age today. And I don't know how many of you saw last week that there was in the magazine section of the Saturday Age, there's quite a big spread on Elton John and David Furness and their son Zachary that had been born to a surrogate in the United States. And it was quite a well-rounded, well-researched, supportive article about these two people becoming parents. So I was interested to look at the letters section of the magazine today to see what the response was. And let me read you two of them. There were 4 letters in response. So one of them says, "Thank you, Good Weekend, for the front page photo of David Furnish planting a kiss on the cheek of Elton John. I don't really care that the receiver of that kiss is a famous singer, and I don't really care that they have a son. What they do with their lives is their business. What I do care about is the fact that this great-grandmother has lived long enough to see a magazine have the courage to ignore all the homophobia and to print and be damned."